How were you employed?
I was employed at the White House on the President's staff.
And what position did you hold there?
I was a staff assistant to the President in the schedule and appointments area.
Now, how did it come about that you joined the campaign, which, as I understand, did that mean the Committee for the Re-election of the President?
At that point in time, it was the Citizens Committee for the Re-election of the President.
How did it come about that you took that position?
Mr. Herbert Kalmbach, President Nixon's personal lawyer at that point in time, called me at the White House one day, indicated to me that he wished to talk to me. Would I come to California, which I did. I spent an evening with he and his wife where we discussed the proposition of the organization of the re-election effort for President Nixon. His specific concern was in the finance area. He was looking for someone who had experience from the 1968 campaign to be the first one in, essentially, to set in motion the personnel, organization, and so forth, the early stages and planning stages of a full-fledged presidential campaign.
Was any other person at the White House involved in your selection or approval going over?
Yes, sir, that's correct. In my conversations with Mr. Kalmbach, he indicated to me that before I made a final decision, since I was working at the White House, that he wished me to discuss this matter with Bob Haldeman, which I did upon my return from California.
And you had that discussion, and did he approve your going over to work in the campaign?
Yes, sir, he did.
Now, you said you had a number of positions. Could you just very briefly outline the positions you had in the campaign?
Yes, sir. The Citizens for the Re-election of the President was really formed after I went across the street to what has become our headquarters and remained a headquarters building throughout the campaign.
You have your testimony and your forthrightness have renewed my faith in the old adage that an honest man is the noblest work of God. And none of these questions reflect on you in any respect.
Thank you, Mr. Chairman.
No. Now, there was a good deal of consternation among the officers and employees of the committee to re-elect the president when it was reported on the morning of June 17th of 1972 that one of the employees of the committee, Mr. McCord, and 4 other people had been arrested in an act of burglary during the early morning hours of that day, wasn't it?
Yes, sir.
And that was the time that Mr. Liddy made the statement to you to the effect that some of his boys had been caught in the Watergate and he'd made a mistake in letting one of our people participate in the matter.
Yes, sir, that's correct.
Yes.
He didn't say they were caught in the water.
Excuse me, Senator, he did not say my boys were caught last night in the Watergate. He just said my boys were caught. There was no direct connection with the Watergate.
Well, you inferred what he was talking about?
Not until after I read the newspaper, Senator. He made that comment to me before I knew of the break-in.
Now, the first person you had any conversation with about this, Mr. LaRue?
I'm not sure precisely the sequence, whether it was the Magruder conversation or the LaRue conversation in that week. It could be either one.
Yes. Well, Mr. LaRue came and talked to you. That's Mr. Frederick LaRue, isn't he?
Yes, sir.
And he was an aide to John Mitchell.
Yes, sir.
And had served with John Mitchell in the Department of Justice, hadn't he?
I'm not sure my own knowledge. That last I knew of Mr. LaRue, he'd been at the White House.
Well, anyway, he came to you and told you he was investigating this matter at the request of Mr. Mitchell.
Yes, sir.
And at that time, you had been notified that the FBI wanted to see you.
Yes, sir.
And Mr. LaRue told you not to go down and see the FBI until you had seen Mr. Mitchell.
Yes, sir, that's correct.
And so you went to see Mr. Mitchell, and you told him you were much concerned about what had happened.
I was asking generally for guidance restricted to that situation. I guess what I was hoping for was an explanation that everything was all right. I did
Yes.
get no such guidance.
And the only advice you got on the subject was a philosophical observation that when the going gets tough, the tough get going.
Yes, sir.
Well, that's a sort of enigmatic expression that's worthy of the Sphinx, I guess. I don't quite understand it all, but...
I didn't really understand
how
either.
long was it after that before Mr. Mitchell left the committee?
Senator, I must admit that when I received news of Mr. Mitchell's departure when I was in Bermuda, that same thought did cross my mind as well. I had heard of that when I was in Bermuda, which would be probably, I guess it was July 1 that he resigned.
Well, what time did this conversation with Mr. Mitchell occur about when you said that when the going gets rough, the tough get going? What day of June was that?
I'm not precisely sure, but I think it was midpoint of that first week, probably the 21st or 22nd of June.
Now, Mr. Mitchell left on July the 1st.
Yes, sir.
Then you were so much concerned about what had happened that you requested an opportunity to speak to Mr. Haldeman.
I am not sure, in all fairness, Senator, that I may have not specifically asked to see him. I sought people out feeling that he personally should know certain information, yes. Whether it was transmitted to him or whether they would arrange an interview directly with him was not decided until the next day.
In other words, your concern was so great that you wanted an opportunity to communicate with someone in the White House your misgivings.
Yes, sir. At this point in time, my judgment was that there was a strong possibility that the entire, essentially high command of the political side of the campaign was involved in this affair, and that the only way to look at it essentially from an internal standpoint was to get someone in the White House at that point to take a look at their own campaign organization.
Now, you did go to the White House.
Yes, sir.
And that was the 23rd about?
Yes, sir, it was the 23rd.
And you got to talk to Mr. Dwight Chapin, the President's Appointment Secretary.
Yes, sir.
And you told him that you were very much concerned about this, what had happened.
Yes, sir.
And Mr. Chapin suggested you take a vacation.
Yes, sir, he did.
Mr. Chapin didn't suggest that you talk to Mr. Haldeman.
No, sir. I made the assumption that if he felt that I was that overwrought and with the information I'd given him, that presumably he would convey that information to Mr. Haldeman.
Well, didn't you think it was time for some honest man to be overwrought?
I was overwrought,
yeah.
Yes, sir.
And Mr. Chapin tried to impress upon you the fact that that it was necessary to protect the president.
He made that comment, yes, sir.
Well, after you saw Mr. Chapin, then you talked to Mr. John L. Ehrlichman, didn't you?
Yes, sir.
And you tried to tell him about it.
Yes, sir.
And Mr. Ehrlichman said, you told Mr. Ehrlichman that it was evident to you that somebody external to the campaign should look into this matter.
I'm not sure whether I precisely said that. Certainly my purpose in being there, which I think I conveyed, was that there's a tremendous problem over here that somebody needs to take a look at. Yes, sir.
In other words, the idea you were trying to impress upon Mr. Ehrlichman was that somebody in the White House or somebody outside of the committee to re-elect the president should make an investigation of this matter.
Whether I put it in quite those strong terms, I was trying to express a concern that there was a major problem in my judgment at the campaign. Yes, sir.
Which ought to be investigated by somebody other than members of the committee to re-elect the president.
Yes, sir.
Yes.
While Chairman Senator Sam Ervin is questioning...
It's just been placed up on the easel to my left. Could you give us an accounting of the individuals who received cash disbursements, and as you do that, could, to the best of your knowledge, tell the committee what was the basis of that cash disbursement? Why was the money given, if you know?
Yes, sir. Would you like me to take it in the order you have it on the chart there?
Yes, I think it'd be an easy way to do that.
In the case of Mr. Kalmbach, he received cash...
Speaking of Mr. Combach, you're speaking of Mr. Herbert Combach?
Yes, sir, that's correct. In the case of Mr. Combach, he, in the period of March 71 up until Secretary Stans came into the campaign, was essentially my senior, from whom I took instructions. He was the principal fundraiser for the President's re-election campaign during that period. He, over this period from March until April 7th, received, to the best of my recollection, approximately $250,000 in cash. I would qualify that by saying that in raising the funds, there were occasions, and I cannot give you what proportionate amount, where he would raise the funds, not turn them into me, but give me the name of the donor. So in terms of my own internal bookkeeping, I would report a receipt from that individual and a disbursement to Mr. Combach. So the entire $250,000 figure, that amount of money did not physically go through my hands.
Now, do you know of your own knowledge why Mr. Combach received, either by holding on to receipts of his own or by actual disbursement by you, this amount of $250,000?
No, sir, I have no knowledge.
Did you receive any receipt from Mr. Combach concerning any money that was received by him from you?
No, sir. Not only in the case of cash, but in this entire pre-April 7th period, receipts just were not used in the campaign period.
All right, then, will you go to the next person listed?
Mr. Gordon Strawn, who was the political liaison between Mr. Haldeman at the White House and the campaign committee. This $350,000, Mr. Combach, on a day just prior to April 7th, and I'm not sure of the precise date, but my best recollection would be within 10 days prior to the effective date of the new law, came to me and indicated that he had had a request from the White House for $350,000 in cash. Would I get that together for him? In the conversation, he indicated that he talked to Bob Haldeman. At some point in the same day, Mr. Strawn was present in the committee. Mr. Combach indicated to me that Mr. Strawn would arrange to have this picked up. I had put the money in a briefcase, and I do not believe I was there when the money was physically picked up, so I cannot confirm that Mr. Strawn, in fact, personally picked this up. But I either turned it over to Mr. Combach or to my secretary. I believe I was going out to lunch and was not there when this was picked up.
Now, with regard to that $350,000 and any other cash, could you tell us what denominations generally the cash was in?
I would say generally the cash was in $100 bills, although at times there were 50s, 20s, 10s. At one point I think we even had some $1,000 bills.
Now, with regard to Mr. Porter.
I might add one further remark about the $350,000. To the best of my recollection, after having the authority from Mr. Combach to do this, there was a meeting in Secretary Stans' office at which he was present and I was present. I do not believe this was the subject of the meeting. I think it was a very brief reference. My recollection is that Mr. Combach indicated to Mr. Stans that he had had this request for $350,000, that he'd asked me to get it together, and my best recollection is that Mr. Stans said fine.
Now, did you know, or do you, of your own knowledge, the purpose or reason for the $350,000 being sent to the White House?
No, sir, I did not.
Would you go to the next person, please?
Mr. Herbert Porter, who was a member of the staff of the Committee for the Re-election of the President. He was in charge of scheduling surrogates, speakers for the President, in place of the President. This $100,000 covered a period probably of starting in either December of 1971 or January of 72. He had a blanket authority to draw cash funds from Mr. Magruder. He would come to me and indicate on various occasions, I need $10,000, would you have it ready for me? This $100,000 is not a single disbursement. The increments of disbursement or distribution would probably be in the range of $10,000, $15,000 over a period of time running up to April 7th and beyond. To the best of my recollection, I turned over approximately $6,000 to Mr. Porter following the April 7th date, under my understanding that these were committed funds. In that case, Mr. Porter, I understand from his testimony to the General Accounting Office, puts the figure higher at $11,000. As I say, this is from memory. I would not dispute his recollection. And I believe he also recollects the total figure to be somewhat less. I had instructions, and I forget who from, possibly Mr. Magruder, that Mr. Porter would receive no further funds after April 7th. When Mr. Porter came to me with that request, I went to Mr. Stans. I asked him, I indicated to him that my clear understanding was that Mr. Porter would no longer receive any cash funds. He indicated to me at that time that that was his understanding as well, that he would take the matter up with Mr. Mitchell and let me know. On his return, he indicated to me that I should continue making payments on request from Mr. Porter.
Now, I think you've indicated that Mr. Porter had a blanket authority from Mr. Magruder, and then later you checked, or was checked, with Mr. Mitchell. Generally, who had the authority to approve your making cash payments to anybody?
In the earliest period, it would have been Mr. Kalmbach alone. He did not physically spend much time in Washington, D.C. He'd be in and out every week or two. He would visit with Mr. Mitchell. At some point in time, fairly early, he indicated to me that, and I believe initially it was with regard to all funds, that I was not to disperse any money without Mr. Mitchell's approval.
And this was what period are you now talking about?
This would be prior to Mr. Mitchell leaving the Justice Department. Would have been in probably the summer of '71.
And did you check with Mr. Mitchell to get his approval in making cash payments?
What happened in this regard was essentially that I don't believe any cash payments came up before the authority issue was resolved. What had been done prior to my assuming the disbursement side of the campaign, going back to the Citizens Committee, when we first moved into the campaign, before there was a division of the finance and political arms of the campaign, Mr. Harry Fleming was handling the disbursement side, and I was handling the receipt side. During that period of time, he had established a procedure with Mr. Mitchell of sending down a monthly budget in writing. I inherited that procedure from him, and with regard to the operating expenses of the committee, each month I would send down to the Justice Department a memorandum outlining the projected expenses of the campaign at that point for the following month. Generally, his secretary would call back and say, fine, so that anything that fell within that budget would be approved in that kind of authority. Any extraordinary item, I would have to call him or call his secretary and ask him.
Now, when you say call him, you mean Mr. Mitchell?
Yes, sir.
And his secretary, who would that be?
Miss Lee Jablonski. What was happening was Mr. Magruder was meeting with Mr. Mitchell regularly at the Justice Department with regard to planning for the political side of the campaign. During those meetings, he evidently was discussing financial matters, expenditures, and so forth, and getting clearance from Mr. Mitchell to go ahead and make those expenses. Following the strict instructions I had from Mr. Kalmbach, when Mr. Magruder came back to me and said, this has been approved, I would turn around and call back down to the Justice Department. I understand from Lee Jablonski at that point in time that Mr. Mitchell was getting irritated about being double-teamed on the same issue and issued instructions for Mr. Magruder and I to work out the clearance authority for expenditures. This was resolved in terms of Mr. Magruder saying to me that anytime I ask you for money, you can count on the fact that this has Mr. Mitchell's clearance. Conversely, he indicated to me that anything I said with regard to the Finance Committee, he would assume that I had Mr. Stans' permission. Although Mr. Stans has not come into the campaign at that point, it was known that he would be assuming the finance chairmanship.
All right, now, with regard to that $100,000 approximately that Mr. Porter received, do you know of your own knowledge?
Mr. Liddy's situation is very similar to the Porter situation.
Now, when we're talking about Mr. Liddy, who is Mr. Liddy?
Excuse me. Mr. Gordon Liddy, it was at that point in time, the period of time he began receiving cash payments, was general counsel to the political committee, the committee for the re-election of the president. At a subsequent date, he became general counsel for the Finance Committee for the re-election of the president.
And I think the chart shows a total amount of $199,000. Is that correct to your recollection?
To the best of my recollection, yes, sir.
Could you very briefly indicate how that money was paid to him and under what circumstances?
It was a similar type arrangement as Mr. Porter's. He had blanket authority from Mr. Magruder to come to me and give me a figure of how much cash he would need. He generally, up to the time he came to the Finance Committee, these would be generally in the same kind of increments as Mr. Porter received, generally $10,000 or $15,000 at a time. There came a time, to the best of my recollection, very close to the April 7th date, and I'm not positive whether this would be before or after. My best recollection would be that it was before. He came to me with a budget of $250,000. He did not release that from his hand. He merely showed me the figure. He said, I will be coming to you for substantial cash payments, the first item of which will be $83,000. And I would like to pick that up in a day or two. He said, in the case of these additional expenditures beyond, or distributions beyond what I'd given him previously, he indicated that the procedure had changed, that I was to clear each and every distribution from that point on with Mr. Magruder. I called Mr. Magruder with regard to this $250,000 budget. He indicated to me that what Mr. Liddy had told me was correct, that I was to go ahead and pay the $83,000 on request, but that subsequent distributions were to be personally cleared with him by telephone prior to their being made, and he wanted at that time to review both the timing and the amount. Confronted with this, I, at that point in time, took up with Secretary Stans. I went to see him. I indicated to him that it was a situation where we had a budget running into the post-April 7th period out of pre-April 7th cash funds. I said in my judgment, because I'd been sitting on top of the total figures, that it seemed to me that the cash distributions were becoming massive, and that this particular distribution of $83,000 was totally out of line with anything we'd done before. At that point in time, I requested that he reconfirm to me Mr. Magruder's authority to make these kind of decisions, and he indicated to me that he would take the matter up with Mr. Mitchell. He returned from that meeting with Mr. Mitchell, and he confirmed that Mr. Magruder continued to have this authority, that I should pay these funds. And with regard to my question and concern about purpose, he said, I do not want to know, and you don't want to know. At this point.
But you've been a well-interviewed man, of course, the last several months. I don't mean to burden the record with unnecessary repetition, but could you briefly describe to me the subject matter of the several inquiries made of you? I'm particularly interested in the scope of the interrogation. Begin, if you will, with the first investigation. What was the first time you were interviewed? Was that by the FBI?
You're talking of an external
I'm speaking really of any time subsequent to the early morning hours of June 17th, 1972.
I considered initially this investigation began essentially as an internal investigation. My understanding was that Mr. LaRue had that function within the campaign committee.
How did you receive that information?
Whether he imparted that to me, I think, I'm not sure. It was a situation of general knowledge within the committee that he was looking into this matter.
And this was as early as during the day on June 17th, 1972?
I don't believe it quite moved that fast, Senator. I think it was in that early part or mid-week of the week following the break-in.
Was that the first interview you had relevant to the Watergate affair?
I believe so, yes, sir.
Would you tell us the scope of Mr. LaRue's inquiry?
At this point in time, it was very general. It was I would say he was restricted his inquiry essentially into the Liddy matter. I mean, within the committee at a very early period, it was quite obvious, I think, to everyone that the focus was on Mr. Liddy, and as far as any knowledge I had that pertained to that, it would be in the area of the money that I had turned over to Mr. Liddy.
Do you know whether Mr. LaRue had any previous information of his own about Mr. Liddy's participation in any of these affairs at the time he made his inquiries of you?
I have no such knowledge, Senator.
What was the nature of the inquiry that Mr. LaRue made of the Liddy situation?
Essentially, it was seeking the information from me of sort of the dollar figures. Well, I think once he had the dimensions of it, as I believe I mentioned this morning, he came back to me saying this is a very politically sensitive issue. We need to come in with a lower figure. That point, it sort of broke, and I understood Mr. Martin as being relatively external in the sense that he had joined the committee shortly before my interview, that he had picked up sort of the reins of the investigation. Following Mr. Marty, and then it would be Mr. Parkinson and Mr. O'Brien.
Did they inquire of you about Mr. Liddy's functions and responsibilities in the committee, or was it limited just to the payments to Mr. Liddy by you?
I think there was a total awareness of Mr. Liddy's function, at least as it was supposed to be. There were no inquiries in that regard. It was purely with regard to the financial payments to him.
But no questions were put to you about Mr. Liddy's functions, his involvement, his responsibility for the Watergate episode?
No, sir.
What was the next interview you had?
Following the Martian interview, which was that was on the 24th of June, just prior to my departing for Bermuda.
And by whom?
This was Mr. Martin's interview I'm referring to.
Thank you, sir.
He, again, was asking and concentrating on the Liddy payments, also Mr. Porter's payment. I think a far more comprehensive approach to the general financial dealings than had been the case with Mr. LaRue.
What was the next episode?
It's when I sought out Mr. Parkinson and Mr. O'Brien on the evening of July 6th.
And what was the essence of that conversation?
That conversation was approached by me to advise them of the facts I knew, because they had not sought me out at that point. It was in the face of 9 of the personnel associated in the finance area having already been subpoenaed before the grand jury. As I indicated this morning, I felt there was a very severe problem that needed to be addressed, and I sought them out to impart that information to them.
What was the next time you were interviewed or had a conversation about the Watergate affair?
I think I've skipped over the FBI interview.
I believe so. Would you go back and identify that by date and tell us the scope and extent of the FBI inquiry?
I believe that was in midweek, probably the 21st or 22nd of June, and it was a interview purely on the question of whether I knew Mr. Alfred Baldwin. Was he an employee of the committee? They asked to have our records made available to them to check out those facts. It was very brief and purely on that subject.
Purely on the subject of Mr. Baldwin?
Yes, sir.
Were any questions asked of you, of Mr. Magruder, of Mr. Dean, of Mr. Hunt, Mr. Liddy, Mr. McCord, Mr. Barker, or anyone else except Mr. Baldwin?
No, sir. The sole subject of that interview was whether we could identify Mr. Baldwin as having been an employee of the committee.
Could you?
No, sir. I'd never heard of him.
Do you have any idea why the FBI limited its inquiry to Mr. Baldwin?
No, sir, I do not.
Did it seem to be limited to a particular purpose? Did they express a reason for wanting to know particularly about Mr. Baldwin?
They indicated, the agents who were there at that time, that they had information that Mr. Baldwin had been involved in a demonstration. I'm not sure. They did identify where it was, but I've forgotten where that was.
But no one asked you about the Watergate break-in in the course of that FBI interview?
No, sir. It's never mentioned.
Nobody asked you about Mr. Liddy?
No, sir.
Mr. Hunt?
No, sir.
Mr. McCord?
No, sir.
Money?
No, sir.
Accounting?
Money only in the sense of was Mr. Baldwin on the payroll or had we paid him any money?
And no one asked you about the $100 bills that were found with or on the defendants in the Watergate trial who were involved in the illegal entry into the Democratic National Committee headquarters?
No, sir.
Did any member of the FBI or the Justice Department ever discuss any of this with you?
The next occasion I had to meet with the FBI was following my resignation, which I believe was on a Friday, July 14th. I think I'm correct in this, that they were present at my home the following Monday morning and every morning thereafter.
Well, I'm not... When did you resign?
On a Friday, July 14th.
And the following Monday, which would have been the 17th of
Yes,
July, the FBI was at your home that morning?
Yes, sir.
And each morning thereafter, did you say?
The problem there, Senator, was that on that occasion they were very much interested in the Watergate matter. And I indicated to them that I felt because there was a possibility on my part of technical violations of the campaign law that I wished to be represented by an attorney before I talked to them, but that I would be happy to cooperate with them. At that point, I was in the process of receiving a refusal from one attorney, and it took me a day or two to get another, and they leaned on me fairly heavily during that period until I did have an attorney.
All right, when you had an attorney, when did you then talk to the FBI about the broader range and spectrum of Watergate material?
There was never an independent discussion with the FBI. They were present the first time I talked to the U.S. prosecutors, Mr. Silbert, Mr. Glanzer, Mr. Campbell.
When was that?
It was on July 20th, I believe, Senator. Yes, I believe that's correct.
I'm sorry.
July 20th.
July 20th?
Yes, sir.
And tell us briefly what transpired in that interview. Who was present, where it was held, and the substance of the interview.
It was in Mr. Silbert's office. Present were myself, my attorney, Mr. Stoner, Mr. Glanzer, Mr. Campbell, and I believe I'm correct, 2 agents from the Federal Bureau.
And what subject matter was covered?
The entire Watergate matter.
What did you tell them?
What I've told you gentlemen here this morning. Excuse me, Senator. We had really 2 sessions with him. We did not cover all the material on one occasion. I believe, for instance, the discussions about the Magruder approach and so forth were covered in a session that was a day or 2 later.
You're talking about the indication by Mr. Magruder that you should perjure yourself?
Yes, sir, that's correct.
That was covered in the second interview
Yes,
with the
sir.
U.S. Attorney's Office?
Yes, sir.
Was that matter ever brought out in the trial of the Watergate defendants?
No, sir. No, the trial. Sorry, the trial. No,
Was it ever discussed before the grand jury?
Yes, sir, it was.
Were you asked those questions by the U.S. Attorney's Office?
Yes, sir. I would say with regard to my grand jury testimony that I believe I spent about an hour before the grand jury, and my best recollection is that approximately half of that time was devoted to the Magruder question.
Mr. Sloan, how would you characterize, if you can characterize, the interviews you had with the U.S. Attorney's Office and the FBI? Were they thorough and searching?
The FBI, in terms of the interviews I had with the U.S. Attorney's Office, they were there as observers. I really have never been questioned by the FBI except in the Baldwin matter. I would say that given the time and the information that was available at the time, I feel they were extremely thorough.
Mr. Sloan, one of the responsibilities of this committee is to file a report ultimately on its findings and to recommend, if it chooses to do so, revisions in the Campaign Expenditure Act, electoral reform. Mr. Sloan, on how we could provide for
the inability to look at the new law and its workings in a dispassionate sense.
Thank you, Mr. Sloan. I have one other line of questions, and it won't take very long. You've covered the material in general with Mr. Dash, the counsel for the committee, and Mr. Thompson. I'd like to know a little more about the extent and scope of the knowledge of Mr. Stans and Mr. Mitchell of the Watergate operations, insofar as you have that information.
Senator, aside from what I've read in the newspaper, I have no direct knowledge in either
Did you ever
case.
talk to Mr. Stans or Mr. Mitchell about the Watergate situation?
Not to Mr. Mitchell. I met with Mr. Mitchell only on the one occasion that's been referred to earlier. During that week, I traveled with Secretary Stans. He had numerous conversations with, as I understood it from what I could hear, his end of the conversation, presumably with Bob Marty and Fred LaRue, the people who were understood to be handling the problem from the political campaign standpoint. Mr. Stans was extremely defensive in all the conversations I heard. He insisted, from the end of the conversation I heard, he said, "Damn it, this is not a finance problem. You guys have to handle it, and you've got to keep it away from Sloan and myself, because we have nothing to do with this."
Do you know what he was talking about?
I'm making an assumption, Senator, but I think a pretty obvious one, that this was about the only issue being discussed at this point. I think
How would you characterize Mr. Stans' attitude or demeanor at that time?
I think he was angry. I think he was upset with the political campaign, the political side of the campaign.
Did you ask him what he meant?
No, sir.
Thank you.
Don't you think this is an area where we need higher standards of ethics which exceed the requirements of law?
Oh, excuse me, Senator, I'm not sure.
I say, don't you think that in this area we should have that individuals should have personal ethics whose requirements exceeded the strict letter of the law?
Yes, sir.
In other words, it's a fundamental principle of ethics that people who handle funds belonging to other people keep records of them, isn't it?
Yes, sir.
Yes. And I judge from your testimony that you had many misgivings as an individual about the way matters were being handled in the receipt and disbursement of funds, didn't you?
Yes, sir, in this transition period.
Now, you were not a policy maker, were you?
In certain areas, but not in this area.
Now, you worked primarily, or entirely, I would say, if I infer you correctly, under Mr. Stans.
Yes, sir.
In other words, your duties were confined entirely to the finance side of the matter, and you had nothing to do with the political aspects of it.
Yes, sir, I would say the only overlap was that I was a member of the Budget Committee that considered total expenditures for the campaign. The Finance Committee role in that essentially would be to say, this is all the money we can raise, you have to set your priorities within those limits. We were a restraint factor on the political spending.
Now, you are not a lawyer.
No, sir.
And you are trying to comply with the old law and the new law. You were acting upon legal advice given you by others.
Yes, sir.
And Mr. Liddy, was he with your legal advisor?
Yes, sir. He was the counsel to the committee at that time.
Now, at times they had approximately $1,777,000 available to the committee to re-elect the president, which were not deposited in banks.
Of that figure, Senator, approximately $1 $1 million was in terms of direct payments to individuals. The balance, the $750,000, was deposited in bank accounts.
Well, was that deposited? How much money was kept in the safe in your office and in the safe in the office of Mr. Stans' secretary?
It's a question of timing, Senator. In the pre-April 7th period, I had kept all the funds in the safe that were in my office. Some point after April 7th, these funds we've discussed here were moved to the safe in Arden Chambers' office. The reason for this being that in pulling together all our records for the pre-April 7th period, there was need for access to my safe, which held all these records, by a great number of people. So it was purely a mechanical transfer to another safe because it was more secure and not as many people had access.
Gavel.
The committee will come to order. Since I'm going to ask the witness questions about the exhibit testified about, to the witness Sloan, entitled Transactions as of April the 7th, 1972, Cash Deposits and Disbursements, including Committed Items. I put this in the record as the exhibit and ask that this copy be handed to Mr. Stans. Now, this represents, as I understand, what Mr. Sloan, the treasurer of the Finance Committee to re-elect the president, testified was the cash receipts of the Finance Committee down to April the 7th, 1972, plus such portions of those receipts had been committed for various purposes. Now, if my arithmetic is correct, $750,000 of this, rather, this shows the total cash receipts of approximately $1,777,000. Is that approximately correct?
That's the figure on the statement, yes, sir.
Well, isn't it a correct figure?
Well,
approximately.
So far as I know from information that I have acquired during the entire course of my chairmanship of the committee, it is approximately correct.
Now, it shows that of this amount, a total of $750,000 was deposited, leaving $1,027,000, of which Mr. Sloan testified approximately an item of $10,000 to the Knopfsinger and an item of $15,000 to Stone may have been paid by checks rather than by cash, leaving a cash disbursement of $1,002,000. Is that approximately correct?
That would be the correct arithmetic, yes.
Now, this committee has authority under Senate Resolution number 60 to investigate every campaign contribution made in connection with the presidential campaign of 1972 or any campaign preceding it. If this committee would call on you as chairman of the Finance Committee to re-elect the president for a statement of the persons who contributed this approximately $1,777,000 to the committee, could you give us such a statement?
Mr. Chairman, I would tell you that $233,000 of it came from Mr. Kalmbach from the 1968 money that he turned over to the committee, and approximately $1,500,000 came from contributors. And given a little time, I could, I believe, continue the reconstruction I have underway as to who gave the rest of the money. I believe that I could tell you where that money came from various records, from discussions I've had with people, from my own recollection and others, I have been reconstructing that figure over a period of time.
Well, are the records now in existence without having to have them reconstructed? That would disclose the names and amounts of each contributor.
There are a considerable amount of records now in existence that would show that, yes.
Well, why are there not complete records in existence that would show that?
Well, at one time, Mr. Chairman, some of the records were removed from the committee's files and destroyed.
Why were they destroyed?
They were destroyed because there was no requirement that they be kept, and insofar as contributors were concerned, we wanted to respect the anonymity that they had sought and that they were then entitled to under the law. We're talking now about contributions before April 7th, 1972.
Were they destroyed before or after the break-in?
They were destroyed after the break-in. I would insist, Mr. Chairman, that there's no relevance between the two.
Well, you say this. In other words, you had no desire to hide the records.
No, may I make a point here?
Destroy them to hide them.
Mr. Chairman, Mr. Sloan's accounting for these funds was given to me on June 23rd. The only reason it was on June 23rd was that he was waiting for Mr. Kalmbach to come back from Europe to check the figure of amounts paid to Mr. Kalmbach. This statement was ready by Mr. Sloan several weeks before the Watergate affair. And he tendered it to me, and I said I didn't want it until he had checked out the figures with Mr. Porter, Liddy, and everyone else as to how much they had received.
Well, those figures merely gave a summary of the totals, didn't they?
Yes, that's right.
They didn't contain any record of the names and amounts of the names of contributors and amounts of contributions, and it didn't contain any records about how the funds were dispersed and used, did they?
There are records that show the amounts of the contributions, and I have been able to verify and reconstruct those. The only thing is missing is...
I'm not talking about the reconstruction. I'm talking about the record that Mr. Sloan gave you on the 23rd of June, 6 days after the break-in.
That record, Mr. Chairman, to the best of my recollection, I destroyed.
You destroyed it?
Yes.
And you swear, and you're stating upon your oath, that there's no connection between the destruction of these records and the break-in of the Watergate, or any fear that the press or the public might find out from these records what the truth was about these matters.
Well, let me speak only with respect to myself. I will say to you that there was no connection between my destruction of the summary sheets given to me by Mr. Sloan and the Watergate affair.
Well, it was quite a queer coincidence, wasn't it?
If it was
it's rather a suspicious coincidence that the records which showed these matters were destroyed 6 days after the break-in at the Watergate.
Mr. Chairman, the adjectives are yours.
So?
The adjectives that you're using, queer, coincidence, and suspicious.
Well, don't you think it's rather suspicious?
No, I don't, Senator.
You think it's perfectly normal, the kind of things you would expect people who had records concerning outlays of campaign funds to destroy the records after 5 men are caught in an act of burglary with money that came from the committee in their pockets?
On April 6th, I asked Mr. Sloan to build up the records of all the contributors, and he did so. I asked him on April 10th, before I left on my vacation, to balance out his cash account. He did both of those things, pursuant to my requests. Now, the fact that they came to me after the Watergate was pure and innocent coincidence.
Well, why did you destroy the records?
For the reason I've already said, Mr. Chairman.
Well, you not only destroyed the prior records, but you destroyed the record he made you on the 23rd, after the Watergate.
I don't know what you mean by destruction of prior records.
Well, don't you know that Mr. Sloan destroyed the records of his records as treasurer?
Mr. Sloan only destroyed, to the best of my knowledge, one book of account as treasurer, and that he did, according to his own testimony,
yes,
on the instructions of Mr. Kalmbach.
Yeah, and that was the only book of accounts he had, wasn't it?
Oh, no, he had hundreds of books of accounts.
Can you produce them?
I have seen some of them since. I never saw the books of account during the time they were being created.
Mr. Stans, don't you know that the records he destroyed were the only records he had in respect to these, the only original records he had in respect to these cash accounts?
The record that he destroyed was, so far as I know, the only original record he had of these cash transactions. That's correct.
Yes.
But as I've said, we have been able to, Mr. Sloan has been able to reconstruct the expenditures by this account that you have before you, and I have been able to reconstruct the contributions, and we can account for the money, I believe, quite accurately.
You have reconstructed the totals of the expenditures. You haven't reconstructed any records which show what the items for which these expenditures were made, have you?
Mr. Chairman, Mr. Sloan has reconstructed this list of expenditures, and I do not know the items for which these expenditures were made. I have testified to that.
Well, don't you think it was very unwise on Mr. Sloan's part to destroy the original records, the only original records they had of cash amounts received and expended?
I didn't get your question, sir.
Don't you think that it was very unwise on the part of Mr. Sloan to destroy the only original records of cash receipts and expenditures?
There were reasons at the time. In retrospect, we would have saved an awful lot of questions if we had kept them. But we had reasons which we believed were valid and which were based on legal advice. But we did not need to keep these records.
Was Mr. Liddy the one that gave you the legal advice to destroy the records?
Mr. Liddy was one of those who gave us legal advice. I remind the chairman, in all fairness, that at the time Mr. Liddy gave us the legal advice, he was in good standing as our counsel. There was no reason to suspect him in any way, and he was doing a good job as counsel. Now, but I did get opinions from others, including John Dean and including Romer McPhee.
Why did you destroy the summary which Mr. Taylor made and gave you on the 23rd of June?
The summary which Mr. Sloan gave me?
Yes.
I have testified before that I had it on my desk for a few days, that I was interested in the names of the contributors because I wanted to be sure that we had a record of that. That I was interested in the balance he had on hand. That I was not interested. It was not my concern or interest to know who the disbursements had gone to. Mr. Sloan had balanced that all out with the people who had gotten the money.
Well, what I'm asking you is, why were you interested in destroying the things you were interested in?
Because...
Mr. Chairman, I wonder if we can have some order in this hearing.
I will ask the members of the audience not to demonstrate their...
For two reasons, Mr. Chairman, which I will try to explain again. Number one, it was possible to determine at any time from remaining records and from the recollections of people who had given that money. Number two, under the law, as we understood it, based on advice of counsel, there was no requirement that we keep these records. And as I testified yesterday, the opinion of counsel was to the effect that we didn't have to keep any records before April 7th if we didn't want to. Now, we've kept 99% of our records. Except you kept no records of all the cash receipts and expenditures. Well, that's not quite correct, Mr. Chairman. We have kept some records, and we have been able from those records to reconstruct what has happened.
Well, why destroy your previous records, and why destroy your subsequent records, and reduce yourself to the necessity of reconstructing something that you already had and destroyed?
Very simply. For the reason
it's too simple for me to understand, really.
Well, Mr. Chairman, for the reason that we were seeking to protect the privacy, the confidentiality of the contributions on behalf of the contributors.
Mr. Stans, was it the attitude of your committee and your attitude that the American people are not entitled to know who was making political contributions to influence the election of the President of the United States?
Mr. Chairman, if you'll permit me, I'd like to answer that in some detail. Drawing partially on my testimony of yesterday, at which part I believe the Chairman was absent. The laws in effect prior to April 7th relating to candidates for nomination did not require any reporting of any kind, did not even require any bookkeeping. We kept a lot of books, nevertheless. Beginning with April 7th, they did require that all contributions be recorded, and we made an honest and total effort to see that that was done. But with respect to people who contributed before April 7th, there were two parties in interest. There was our committee, and there was the contributor. Our committee didn't care whether those names were disclosed or not, but we felt that we did not have the right to waive the contributor's privacy. If he wanted to tell how much he gave, that was his right. But it was not our right to say how much he had given unless he wanted to. Now, we were confronted with a political situation at the time in which some of the candidates for president had released the names of their contributors. And we had to consider whether we wanted to do the same thing. We met, we considered it, and we decided that we did not, that we were not going to give away the rights to privacy of the individual contributors who had helped in the campaign. That was our decision.
In other words, you decided that the right of the contributors to have their contributions concealed was superior to the right of the American citizens to know who was making contributions to influence the election of the President of the United States.
We didn't evaluate it in those terms. We've evaluated in the terms that it was the Congress of the United States in 1925 that gave the option to a contributor to remain anonymous, and that we had no right to give away his anonymity.
Well, Mr. Stans, do you not think that men who have been honored by the American people as you have ought to have their course of action guided by ethical principles which are superior to the minimum requirements of the criminal laws?
I don't have any quarrel with that, but there's an ethical question in whether or not I can take your money as a contributor with an understanding on your part that you're entitled to privacy in that contribution, and then go around and release the figure to the public.
Well, all the law said, as you construe it, as your counsel construed it, was that you didn't have to make a public reporting of these contributions. The law didn't require you to destroy the records of those contributions, did it?
Mr. Chairman, the law didn't even go that far. The law didn't even require us to keep any records during that period of time, and the advice of my attorney.
But the law didn't require you to destroy the records you did keep.
No, of course not.
Yes.
That would be a silly proposition.
Well, do you think that that men who exercise great political power, as you were exercising, and as the former Attorney General of the United States were exercising, and these other people engaged in the committee work, that they ought to merely they ought to disregard ethical principles and say they have fulfilled their full duty to the American people as long as they keep on the windy side of the law?
Senator, I haven't said that, and I wouldn't say it. I'm saying that I think we have to balance one ethical principle against another. The right of privacy of an individual as against the right of the public to know. The Congress has recognized that as a problem. That's why it passed a new law. And there was no reason that I know of why we should have anticipated the date that law was effective. The Congress, Mr. Chairman, gave us 60 days after the law was effective to operate under the old law.
Yes,
and we did.
You had an old law which required you to report contributions, didn't you?
Only in the case of a general election.
Well, Mr. Stans, you were solicited and collected millions of dollars in campaign contributions. Is that right?
Yes, I did.
Some of the people you solicited were even your friends, weren't they?
Yes, of course.
Don't you feel some obligation to them to take an interest in what was happening to the money they contributed?
Well, of course I did.
In view of your position as finance chairman, didn't you think that these people were relying on you taking an interest in what happened to their money, at least to the extent that it was used for legal campaign purposes?
I think they had every right to assume that I would not do anything in contravention of the law.
Well, now, can you tell us what